Good morning to you all and welcome to our webinar for the secondary sector, which we've titled Schools, Admissions Policies and Time to Act. And it's our hope in the course of the next, I suppose, 30 or 40 minutes to try to explain to you some of the provisions or the main provisions of the Admissions Act in relation to your admissions policies and why it is time to act. This is a webinar primarily focused on the secondary sector. We had one yesterday for the primary sector. And I want to say at the outset, we're really absolutely thrilled with the amount of interest. There are approximately 300 principals who have registered for this morning's webinar, which is absolutely fantastic. Can I start by introducing my colleagues, Liam Riordan and Catherine Kelly. Liam and Catherine and myself are going to try to answer a lot of your queries. We had hoped to try to make this an interactive session with the chat function that is possible on webinars, but unfortunately the numbers of participants are so large that we're not able to do that. But we have taken a lot of questions from you and we hope to address a lot of those as we go through the session. So let's get stuck into the meat of schools admissions policies, time to act. Some key dates firstly. 30th of April, very soon. There's an obligation in each school to submit your draft policy to your patron. You're supposed to have already consulted or be consulting with your parent body and staff. And obviously in this crazy times that we're in now, we understand the challenges of that. So whether it's remote consultation, but we understand that you have to do your best in these difficult circumstances. The next date is the 15th of September. Your patron is supposed to have approved your draft policy by that date. If there are modifications, there's a final date for completion of those up to 29th of September, and the 1st October is the date by which schools may commence the operation of their admissions policy and admissions process. Now, I'm not going to spend time on these. You'll be familiar with the Education Act 1998 and you've needed to have policies since that date. And you'll also be familiar with section 15(2)(b), that you're accountable to your patron for upholding your characteristic spirit, or as lots of secondary schools, denominational schools might call your school's ethos. Now, the Act itself, it was passed in 2018. Little bits of it were commenced prior to 2020, but the vast bulk of it was commenced on the 1st of February 2020. And the date of the end of April for submission for your policies arose because that date had to be 3 months from the date of commencement. So that's 1st of February to the 30th of April. Now the Act has a large number of sections and subsections in relation to the policy, admission policy itself, section 62. It also has provision for a new concept of the annual admissions notice. We'll be looking at that, section 63. And like lots of areas, the department has published a circular, 7 of 2020, which contains templates both for the policies and for the admissions notices. One school has asked us, are we obliged to follow the templates? Well, not strictly speaking, are you obliged? But our advice is, follow them unless you have good reason to do otherwise. That's really the basis for our advice. We want to get stuck in straight away to one thorny issue, and that's oversubscription. It only applies to some schools because many schools are not oversubscribed. So if you're oversubscribed, it's obviously a potentially thorny issue because you're going to have to say to applicants, you can't get in. And obviously that can give rise to disappointment or challenge. So the first question that arises is, well, can you prioritize? Well, you must prioritize if you're oversubscribed because you have to have some basis for who you let in and who you don't let in. So you can prioritize. There is a permitted prioritizing for siblings, children of present or former students. That is specifically permitted. One issue that we've got a lot of questions on is, are you entitled to prioritise children of teachers or children of staff indeed, children of teachers or children of staff? Many of your policies have a priority traditionally for that, for perfectly understandable reasons. So I'm going to ask Liam to address that, because he's been dealing with a lot of queries on that and has looked into the thing really in detail. Liam, can you help us on priority for teachers mainly?
Thank you, Ian. Yes, this is a big issue for many schools, and we're aware that there has been some mixed messaging from the Department of Education and Skills on this particular issue, particularly in the primary sector. The problem is with the wording in the Act. Section 62(7)(e)(4) to be precise, says that when you're considering an application for enrolment, you cannot take into consideration the occupation, financial status, academic ability, etc. of the parents. And by definition, if you prioritize the enrolment of children of staff, you are taking into consideration their occupation. So on the face of it, the Act prohibits prioritizing the children of staff. However, this does appear to be an unintended consequence of the Act, in that when the Act was going through the Oireachtas, the minister at the time, Richard Bruton, made it very clear that he favoured schools retaining the discretion to prioritise the children of teachers. Now, he specified teachers, not staff, but in any event, the way the Act was passed, it still contains this particular section 62(7)(e)(4), and on the face of it, that does prevent schools from prioritising the children of staff. So if a school were to decide to retain that provision, there has to be a health warning. Even if your patron were to agree with it, it could give rise to a Section 29 appeal, or indeed it could even give rise to somebody challenging the school directly in relation to it. But you're probably talking about a small number of children in any given period of time, so it may not. It may be a bigger problem in theory than it will be in reality. So, I mean,
what you'd really say is, if it's something that you feel really important and you want to include it, but there's a question mark over it.
Yeah, exactly. Yeah. That's it. Yeah.
Okay.
Could be challenged, could be overturned.
Catherine, in some voluntary secondary schools, we've seen policies that provide a priority to, for example, nephews and nieces of members of the trustee body. Do you have any view whether that priority could be allowed for?
Yeah, well, this clause is in a lot of policies, and it's very important for schools to maintain that clause for various different reasons. And I would say that there's no clear prohibition on putting that in your policy. There's nothing in the Act that states you cannot. So it's up to boards of management to decide themselves whether or not they want to retain that clause. The only thing I will say is that a disappointed parent, somebody who hasn't got a place in school, may challenge that clause at some stage. So that again may be the subject of a Section 29 appeal.
Yeah, but there's nothing in the Act to prevent it. Yeah.
No, there's nothing.
No. Okay, let's look at the admission policy and look at some dates. Publication of admission policy not earlier than the 1st of September 2020 for the following school years. That's clear enough. October the 1st is the earliest date that you can start the admissions process for the following year. Parents must be alert to the process, and it's important that the school, takes it on to alert parents in an appropriate manner. And one important factor is your policy must include a non-discriminatory admission statement. Now, many of you will be familiar with the 9 grounds of discrimination. They're the same for employment discrimination or equal status or whatever it is. So your policy must state that you don't discriminate on any of those 9 grounds. Now, there are exceptions. For example, the gender ground, if you're a single-sex school, there are exceptions. But the primary message is no discrimination on the 9 grounds. There are mandatory aspects of the admissions policy. And I mean, the fundamental principle is that for mainstream schools, there are now only two main grounds for refusals to admit. One is that the school is full, obviously if you're oversubscribed, and the other one is that the parent fails to give a written undertaking to accept the code of behaviour. Now, there are certain other ones. For example, there are grounds for special schools, and there are exceptions. Single-sex schools, you don't have to admit children of the other gender. So I mean, that they are important principles, two grounds to refuse to admit. And in that context, two thorny issues have come up in a lot of the questions that we have been asked prior to this webinar around what we call our exceptional circumstances clause that we drafted probably about 15 years ago. Now that clause basically says that in exceptional circumstances, you may be entitled to refuse to enroll a pupil. For example, if a student has such special need that even with additional resources provided by the department, you can't provide the student with an appropriate education, or that they pose a very serious health and safety risk. Now, we're not talking about what I might call ordinary special needs. Schools are welcoming. We also understand that. Many of your policies say you welcome, and rightly say, you welcome special needs students. We're talking about the exceptional circumstance here. Liam, can we include an exceptional circumstances clause in our policy now?
In a word, Ian, no, you can't. In giving that advice, we relied on the Education Welfare Act. And the Education Welfare Act says that you can only refuse to enroll somebody consistent with your admissions policy. The Admissions Act now says, as a matter of statute, that the school has to admit each student seeking admission to the school, other than in the very limited circumstances that you mentioned there a minute ago. So that exceptional circumstances provision, that's gone, I'm afraid. The only schools that can do that now, or that can have that, or something like that in their policy, are special schools who can refuse to enroll if the criteria for enrollment aren't reached, or in the case of a special class, such as an ASD unit. So, for example, a school with an ASD unit could refuse to enroll a student into its ASD unit who didn't meet the criteria for enrollment. However, if that student wished to enroll in the mainstream part of the school would have to enroll that student, even if that student had a range of disabilities which were greater than what would have qualified the student for a place in the ASD unit, for example. So this could cause problems into the future. We'll have to see how it works out.
That sounds like a kind of a slightly bizarre situation.
Yeah.
Yeah. And yeah. What about the health and safety? We're talking about now exceptional circumstances. What about the health and safety clause that has been in many policies? Can we operate that? And what does the Act say?
I would advise no, that you wouldn't be able to use that clause under the Act. I have seen it in admissions policies before, and we have used it. Especially, I had a case where a student had used a knife in a school and was then seeking a place in another school, and the school heard about this and refused him a place on the grounds of health and safety, a risk to both staff and students. The situation now will be, you won't be entitled to any information from the other school because you're not entitled to reports. So you will have to admit that student if you have a place, and then it will be up to the school to use the code of behaviour in relation to any incidents with that student. I would also say that you'd have to look at maybe getting in place some kind of looking at the special educational needs of that student and getting resources in place. But my advice would be that you'd have to admit him.
And Catherine, you and I had a case last year, I think it was reported in the media, of a student who had 80 incidents of assault on other students or on school staff and had been expelled. What we're still saying is another school would have to enroll that student and deal with the student under his code of behaviour. Which
is not ideal,
no.
But that's the way it is, yeah.
Okay, thanks for that. Okay, just a couple of quick questions about our information about the annual admissions notice. What does it include? It must set out the number of places being made available in the intake group in each year. In the case of a school with special class, the number of places in special class, and how the admissions policy and the enrolment forms can be obtained. A few things about dates. This must be in the admissions notice. The date on which the school will begin and end accepting applications, and there's a 3-week minimum for those dates. Also, the period during which the applicant shall be notified of the decision in relation to the application, and there's a 3-week maximum of that date. And finally, the period during which the applicant must confirm acceptance of an offer made. Now, there's no period specified in there, but we would strongly advise that you put in a period there in your policy, because if you don't, parents technically have an open-ended period in which to confirm acceptance, and that's going to leave you in a very difficult situation come September the 1st, because you won't know who's going to come in your door or not. Some practicalities around the annual admissions notice. The Act says that in any case where offers of admission have been accepted prior to the 1st of February last, the school should set out the number of such offers and acceptances in the annual notice. And I want to come back to that in a minute. It also says that application forms should be available on the school website no later than a week before accepting applications and on written request. Now, Liam, can I come to you in relation to the first bit there? 1st of February 2020, we're really talking here about schools that have had traditionally maintained a waiting list for future years. How is that going to work?
That's it, Ian. And what the Act says, the Act says two things. First of all, waiting lists are gone. There is a 5-year period from the date of the implementation of the Act when they can still be relied upon. There's a 5-year transition period, if you like. And the Act says that if you're a school that has a waiting list and you relied on that waiting list in allocating places in subsequent school years, where before the 1st of February 2020, in response to an expression of interest or an application from parents, you as a school have written to those parents saying that their children's names are on this list and that they will be allocated places from this list, then that is sufficient for you to rely on that list for the moment. You don't have to have received formal acceptances of those offers from the parents concerned. What the Act says is that you have to have put it in writing to the parents that this is what you're doing. If you've done that before the 1st of February 2020, that's okay. If you haven't, you're too late.
Okay, I think that's clear enough. Yeah. So what are the prohibitions? Well, you're prohibited from accepting applications in advance of the 1st of October. There's a you can ask parents to attend for interview, but you can't compel them, and you can't use a refusal to attend for interview as a criterion for admission or otherwise. We all know that there has been a long-standing outlawing, if you like, of taking into account an academic ability of a child. There is an exception for special schools and special classes, which we'll come to in a minute. There is an interesting provision for a cap of 25% of children or grandchildren of past pupils. Now, we said earlier on, siblings, priority for siblings is okay. So this is children of past pupils or grandchildren of past pupils. Liam, talk to me about that.
This came out of a case we had some years ago. Indeed, Catherine acted for the school. Many of our clients will be aware of it. It's known as the Stokes case, and that was a case where an applicant student from a traveller community background was unsuccessful in getting a place, and it was claimed that he didn't get the place because there was a proviso in the policy prioritising the children of past pupils. The argument was made that because for socioeconomic reasons, his parents were less likely to have attended school at all. Therefore, it was indirectly discriminatory of him. Now, even though that case, it was a big saga for Catherine. It went all the way from the Equality Tribunal to Supreme Court. Ultimately, we won. But out of that came this cap on the numbers that you can prioritise. So it is what it is.
And Catherine, just a quick word on feeder schools. Many secondary schools give a priority to local feeder schools. Is that permitted?
Yeah, I mean, most schools would have feeder schools listed, and that's still permitted under the Act, so there's no issue with that.
Okay. So here's some things that schools must do. They must provide a waiting list maintained in priority order and valid for each school year. And that is important because if you get applications during the school year, in other words, not simply from 1st September, you have to admit students in accordance with that year's priority list and waiting list. You must set out procedures if 2 or more pupils are tied for a place. And a number of years ago, we had a rather bizarre situation where the tie occurred for 2 twins. And there was even a crazy suggestion that we'd have to try to work out which twin was born first, but I'm glad to say that we were able to find a different way of resolving that particular issue. You must provide reasons for a refusal and give numbers on the waiting list. So gone are the days of the famous so-called Irish waiting list that nobody could ever find out who was on it and what number they were on it. And you must inform any unsuccessful applicant that they may appeal in the first instance to the Board of Management and afterwards to the DES under what you're familiar with under a Section 29 procedure. Now, this is a new provision. Parents who are disappointed must, before they bring a Section 29 appeal, bring an appeal to the Board of Management. And I said earlier on, and I just emphasize now, the admissions process must be done in the first instance by the principal, not by the board. And it's for this very reason that it is vitally important that the principal and the board is not involved. Liam, do you want to say anything about what that appeal to the board, what issues might arise there?
Sure, Ian. Well, I think this is going to increase the workload for boards of management in schools that are oversubscribed, because it's foreseeable that any parent who was refused a place for their child is going to appeal it in the first instance to the board. I think for boards, it's important that they take the corporate governance, if you like, on this, that they take it seriously, because it's quite possible that they will be, that they could be challenged either by way of a subsequent appeal under Section 29, because this is a statutory function in itself. A parent who was unsuccessful could theoretically judicially review the manner in which the board dealt with that appeal by way of an application to the High Court. So I think schools are going to have to be more careful about this. There's one thing that schools should do, and that is to put in a time limit for making appeals to the board. There's nothing in the Act about this, so schools should put one in, because otherwise, if you have a number of appeals, you can see the difficulties that could create for a board. So at the very least, if you put in a timeline, that'll give you some control over it.
Okay. Catherine, do you want to say anything else about that?
I think it'd be important for the board to have put together some set procedure in relation to how the appeals run, so that it applies equally to each person who appeals before the board. And also, obviously, as we've said, the principal shouldn't be involved in relation to any appeal, because the principal has made the original decision.
Sure. Okay. Thanks for that. Don't want to spend much time on this. Parents must, when accepting an offer, indicate that they've accepted another offer in another school and provided details, and whether or not they've applied, and if they've are waiting confirmation of an offer. This and the next point I'm going to mention were really inserted into the Act at the request of school management bodies, because many schools were complaining that they were having applicants who had applied to numerous schools in the area, and come September the 1st, they didn't know who was going to walk in the door, because the parents were kind of juggling a number of applications. So under data protection, and we all know about data protection and GDPR, Section 66(6) allows a school to provide a patron or another board of management, for example, a local board, with a list of students who have either applied for admission or got an offer, or have accepted an offer. And the student's personal details around that can include the student's name, address, date of birth, and PPS number. Catherine, any guidance on how a school should deal with this type of data from students or parents?
Well, obviously schools have to be very careful about the personal data of these students, and we would advise that maybe a protocol could be put in place in conjunction with the patron on how to deal with that personal data. Obviously, the personal data can only be retained for the allocation of the places, and after that it should be destroyed, and there should be some kind of policy in place in relation to that.
Very good, yeah. So let's talk about the issue of a refusal or withdrawal of an offer. And the Act provides that an offer may be refused or once made can be withdrawn if information contained in the parent's application is false or misleading in a material respect. And I want to come back to that in a minute. Or also, if an applicant fails to confirm acceptance of an offer on or before the date in the admissions notice. So it's important to have that date in there, obviously. Also, if a parent fails to accept in writing the code of behavior. And finally, if the parent refuses to provide details about other offers or other applications to schools. Now, one question that has arisen, that has been put to us is, like, how might a school deal with an application where it believes it has received false or misleading information? And one of the examples that has come up recently is around where the priority is given to residents local to the school, and where there's a suspicion that a false address may have been given. Liam, any comments on that?
Yes, Ian. It's quite tricky, really, because face it, if somebody has brought information to your attention that somebody else's application contains false or misleading information, the chances are that's coming from another parent. While I think if you have evidence that you can stand over that you have been given false or misleading information in advance of your making the offer, or in advance of the student taking up the offer, then I think you are within your rights in withdrawing the offer or refusing to make it. If, on the other hand, you've already made the offer and the student has taken up the place and the student's in the school, well, then it's it's a fait accompli, and I don't think there's much you can do about it. You'll be talking then about looking to expel a student, and I think that wouldn't stack up.
Yeah, yeah.
So it's messy enough, or it could be messy.
Sure. A couple of words on special classes. You are entitled to ask for reports, you know, in relation to a child's special needs. You are also, there's an obligation to accept pupils during the school year if you have capacity. Special needs applicants are likely to apply to a special class and a mainstream and the mainstream school in which the class sits. And Liam spoke earlier on about the somewhat bizarre situation you could have where a student might not be, a special needs student might not be eligible for a special class, but might not be, could not be refused in the adjoining mainstream school, which sounds weird. Just to remind you, the NCSC must approve any change of designation of either a special class or a special school, and that you can invite parents and pupils to interview, but there's no obligation on those students to, or the parents to attend. I just want to say a few words really for, this is more or less for denominational schools. The right to opt out of religious instruction. Now, the Act says this must be included in your policy. It must be included in your policy. This is nothing new. It's been in the Irish Constitution and it's been in the Education Act, so this is nothing new. But the right of a parent to request that their child be excluded from religious instruction relates to religious instruction. And of course, just going back there, there is a big difference between, or there may be a difference between religious instruction and religious education. For example, most of us think that religious education in the junior cert cycle, for example, is very different from religious instruction. And a student would not have a right to be excluded from that type of religious education. And now obviously where students want to be removed from religious instruction, there are of course practical implications, resources implications, supervision or whatever, and schools are grappling with those issues. The Department of Education have indicated that there will be no additional resources for schools around that. Quick word before we finish, minority religions. There are special provisions in the Act for schools of minority religions. There are permitted criteria basically giving priority to members of the minority religion of the school. The school is entitled to provide religious instruction and education to accommodate those members of the minority religion, and also to require evidence of membership of the minority religion, whether that's baptismal certs or other evidence. But these special provisions do not apply to special classes in minority religion secondary schools. So we're come to the conclusion. A couple of general comments. This Act has yet to be road tested. And we think it's going to be road tested like bottle legislation by challenge, with Section 29 appeals, perhaps with judicial reviews, perhaps even with a wider challenge as to the constitutionality of the Act. For example, is the state entitled to dictate what really amounts to almost all the terms of an admissions policy, and the entire process? Is that an entitlement of the state? That may be something that will come up before the courts in due course. Some takeaways, you know that before the end of this month, you need to submit your policy to your patron for hopefully after some consultation. There may be feedback with your patron during that time, and you then need to send your final policy to your patron, and we've given you the dates on that. So there's further just a quick thing, there's some further reading if any of you are interested in our e-zines. They're available for anybody who wants them. And other than that, it really it falls to me to say thank you for joining this webinar. Liam, Catherine and I hope that you found it helpful. We have tried to deal with as many of the questions as we can and many of the hot topics. We are of course aware that we haven't dealt with them all. For any of your schools that want further help, of course, you know that we're available to assist you. You'll all be getting, anybody who's registered will be getting an email with a recording of this webinar if you want to listen to it again. And we're also going to include in the covering email a proposal to any schools who feel that they want a specific review of their policy as to whether it complies with the Act or not. Other than that, from myself and from Liam and Catherine, thank you for listening.
Thank you.
Good luck.